Hi, folks. You're in for a treat today. Next up on TWiL, we've got author Robert Levine, author of Free Ride, Professor Lateef Mtima from Howard University, Tom Merritt and I. And if you are interested in culture, technology, and the interplay of law and business, you're not going to want to miss this one. Next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 181, recorded September 28, 2012. Fire bad, outlaw fire. This episode of This Week in Law is brought to you by ShareFile. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a free 30-day trial, go to sharefile.com, click the radio microphone, and enter TWiL. Hi, folks. It's Denise Howell, and you have tuned in for This Week in Law. And this week, we have a phenomenal panel for you. I'm so excited for this show. Joining us, we've been trying to get him for quite some time, is author Robert Levine, who has written a book called Free Ride, which we will shortly discuss. Hello, Robert. Nice to see you.
Hello. Good to be here.
It's great to have you here from Germany as well. We really appreciate the effort and the time change. And I'm glad that the internet was not angry with you enough to prevent you from getting your cable installed yesterday.
The tubes were kind.
That's good. Joining us from Howard University and the Institute for Intellectual Property and Social Justice is Professor Lateef Mitra. Welcome back, Professor Mitra.
It is great to be back, Denise. This is always one of the highlights of the month for me. So you've given me my treat for October.
Wonderful. That's great to hear. And joining us from the TWiT studios in Petaluma, California, and representing folks in general who make and distribute stuff online for fun and profit is Tom Merritt. Hello, Tom.
Hey, Denise. Thanks for having me back. I will try to represent.
Thanks very much. I know you will. All right, let's get right into it and talk about the book Free Ride. Not all of our viewers and listeners will have read it. So just to kind of recap for you, Robert's premise in this book is that the internet and the companies who most benefit from it, large technology companies, are having an adverse impact on the world of culture as we know it, spanning everything from music to film to television to literature. Because of the, now Robert, jump in and correct me if I am not, adequately summarizing your book. Because of the piracy that has taken place using online tools, the infringement that historically has happened and continues to happen today, and the way that the industry's inability to compete with free makes it impossible for them to develop artists and authors in the way that we have seen happen in the past. Do I kind of have that in a nutshell, Robert?
I think that's fair. I would say it's not so much, competing with free. I try to stay away from that because I think the question is something free or paid? Because obviously commercial TV was free and it made money. It's more like, is the company that's distributing something giving money back to the creators? So, for instance, if you watch a show on NBC, that's free, but money is going back to the creators. If you download something from Pirate Bay, that's also free. Money isn't going to the creators. So I think it's a question of legitimate and illegitimate distribution. And it's also, when you talk about companies getting hurt, it's not only piracy, but it's the deals piracy pushes you into making, the idea that you lose any kind of pricing power. You have to when people say, well, I have to cut the price from my book, otherwise people will take it. It's not only the sales I lose, it's the downward pricing pressure. A book on my subject is unlikely to be a bestseller, I think just by the subject. And, to sell it for $1 is probably unrealistic in my case. If I wrote a great murder mystery, it might be a great business model. a great book on, even a reasonably good book on copyright, you can make your own, form your own opinion. But I think it would be hard to make money selling it for $1.
Okay, so we get the premise of Free Ride, and I do encourage people to go out and read it. We were just talking before the show about how well-written it is. It's very persuasive, and it doesn't necessarily persuade me on all points, I must say, but it's definitely an enjoyable and interesting read. So Professor Mtima
newly out in paperback. Sorry, I'll stop.
Newly out in paperback. That's good to know. Professor Mtima read the book when it came out. It came out in 2011, and that's something else I want to get into at some point. We're going to turn the focus to the publishing industry and the fact that books are fixed. And I bet, Robert, there are a lot of things that you would have liked to include in your book as we sit here in September 2012 that aren't there. Is that right?
Yeah, the only way, writing a book about a subject like this, you're done. You try to include everything you can, and you're done when your editor starts threatening you physically.
Right.
And she's, she's tough.
I bet she is. Professor Mtima read the book when it first came out and was not necessarily persuaded by all the points either. Put up a detailed post on Google Plus about it, which we have in our discussion points for the show. If you'd like to read it in detail, that's at delicious.com/thisweekinlaw/181. As we sit here today, Lateef, do you continue to feel as you did then that the book doesn't quite tell the whole story?
Yeah, and I think that's really the best way to put it. When I read the book, it and again, I think it's a well-written book, but in terms of the substantive points that it makes, it kind of reminded me of like a John Ford Western. That if you watch the Western, and that's the only thing that you see, you have a particular view of the conflict between Europeans and Native Americans. But that's because the movie, when you watch The Searchers, all you ever see is, this wonderful family, and the next thing you know, they're slaughtered, and so of course, the Indians are the villains. But there's so much to the story, of course, that is left out. And when you have all of the facts, then the overall narrative looks a bit different. And so, a powerful advocate can always take selected facts and tell a false narrative, right? And I think that one of the key things, and not just in this book, but in sort of the narrative view of the current intellectual property controversies of some of the major content industry holders, the narrative view that they tell of that story, one of the key themes is that this is about new tech versus the creators, that the new tech, they're making use of content and they're not getting money back to the creators. And as a result, this is a battle between the people who create and the people who use. But from where I sit, that's not the story at all. First of all, the folks on the content industry side have sort of, they would like to append to themselves the label of being creators, but actually they really aren't. They're primarily distributors. So if there's anything, any sort of a way to label the conflict, it's really more a conflict between the old category of distributors versus the new category of distributors. And insofar as creators are concerned, something that we have to understand about the 20th century and 21st century predominant creator-distributor business model. And that's that in some of the industries, like, for example, movies and some TV shows, many of the creative people, their revenue is in no way tied to what happens post-production. In other words, if a director agrees to produce a film, in many cases, the director gets a straight salary for his or her involvement. And to say that later on, if somebody engages in an unauthorized use of the film, and I prefer the term unauthorized use because not all unauthorized use is piracy, but to say that if someone engages in a use that does not result in revenue to the distributor, that means that money is being taken out of the hands of the creator. Well, that's just not true. The creator was never going to participate in that revenue source to begin with. Okay, so once again, this is a problem for the distributor, not a problem for the creator. And then finally, even in those business models in which, in theory, the creators are supposed to receive some share of that revenue, for example, in the recording industry, that's just theory. As most of us know, in reality, the overwhelming majority of the recording artists never see any of the revenues that they're supposed to receive. That, while they're touring and selling records and everybody loves them and the recording industry, pays the hotel bill and makes sure they have a nice limo, everything is fine. And when they cease to be at the top of the charts and the recording artist turns around and says, okay, my heyday is over. Now, can I start having some of those royalty checks that, according to the agreement I signed, I was going to, start receiving? More often than not, instead of receiving a royalty check, what they're handed is a bill. And a bill for, well, we paid for so many things in order to make this record happen. We paid for all kinds of things that you never thought about. In fact, we probably paid for some things that you would never even have agreed to would have to be paid for. And due to some magical accounting, even though your record sales generated X amount in revenue, according to our accounting approach, what you owe us is something like 2 times X. So you're never going to see any actual revenue, and more often than not, that's what ends up being the case. So that's why I say that it's not really a creator versus new tech scenario. The creators aren't getting any revenues from the old model either, and so it's not. This
is a little far-fetched. Do you know what an advance is?
Yeah, I do. I do know what an advance is.
Let me tell you what I did. I'm a creator. I signed a book contract. I got an advance against royalties. That advance was, you can see a bit of my apartment. It's not so big, but it covered the cost of writing the book. I may get further royalties. I may not. But every single artist that signed a deal under the old model, when you say they don't see any revenue, that is 100% factually incorrect. They always see revenue. It's called an advance. That advance is an advance against royalties. They may or may not see future royalties. That's my first point. My second point is, you said that record company accounting is corrupt, and I've covered the music business for 15 years, and I have to say I 100% agree. Music business accounting is notoriously corrupt. But you're talking about a huge problem with the law. You're talking about a huge problem with contract law. That has absolutely nothing to do with copyright. One of the things that's great about copyright, to me, is that copyright gives creators a right. Creators can then enter into contracts. They're free to enter into contracts. Some of them enter into very good contracts. Some of them enter into bad contracts. Some of them enter into contracts that are in between. But what I love about copyright, there are things I don't like, but what I love about it is that it was up to me to make my choice. The old model, I have my choice. I can sign a contract with Penguin. I did sign a contract with Random House. The great thing about what's happening is that I have my choice. I could also sign a contract with Amazon. And I think that's fantastic. I could sign a contract with a new publisher. I could sign a contract with an old publisher. I could have my book only available in ebook. I could have my book only available as a hardcover. I could have my book only available in Japanese. I'm not sure that would be a good idea, but I like having that choice. What piracy does is it takes that choice away from me. This is my right, and they take that right away. All the problems you talk about with contract law are really important. But I think one of the things you have to realize, especially obviously since you're a lawyer, is there's a big difference between contract law and copyright law. Look, record companies have treated artists terribly, but publishing companies have treated artists better for song copyrights. And sometimes sometimes artists have made very bad decisions themselves. I'm not excusing record companies, but my point is that this is really a problem with contracts. My hope for the internet was that artists could go into business for themselves. Artists could sell their work directly to the public. That to me is something that's terrific. That was the original point of the internet when Al Gore invented it. But what's happened, it's very difficult for artists to sell things because the level of piracy is so high, the downward pricing pressure is so strong, that what you have is an information economy where it's almost impossible to sell information. And I think that's really at the heart of this matter. Rather than old models and new models, we're talking about contractual legitimate models and illegitimate models that violate the rights of creators. That's the real issue here. It has nothing to do with old and new.
Okay. So let me jump in there. I want to talk about first copyright law, which there are some things, Robert, that you like and maybe some areas that you don't like, and I want to get into those. And then the business models against the context of the laws that we have and whether those laws should change. And Robert, one of my favorite parts of your book comes in the last chapter, and I'm just going to go ahead and read it here, if that's okay, if I am authorized to read a snippet of your book on the show.
Encourage.
Let's consult with your publisher. And here it is. Copyright laws do need to be revised to bring some order to the internet. We need shorter terms of protection, a way to take quicker action against commercial-scale pirates, and less draconian damages for individual infringers. Specifically, a small claims court for copyright infringement would allow independent artists to assert their rights without burdening the court system and distinguish casual downloaders from money-making operations. Now, I'm not sure I'm on board with if we're depriving people access to the court systems, but going on. To deal with the former, it's much fairer to sue 100,000 illegal downloaders for $50 each than it is to sue 50 users for $100,000 each, and the law should make that possible. Making such suits an unpleasant but routine event like getting a speeding ticket would cut down on infringement as well. Hallelujah. I'm almost 100% on board with that. What do you think, Tom?
You know, the speed limit analogy is actually a really good one. And what I like about the passage that you just read is it points toward the idea of let's actually try to figure out what harm is being done and modify copyright law to fit that. I think one of the big problems we have a lot of times with this debate is screaming and extreme positions on both sides. You have on one side people saying everything should be free, there should be no copyright law, and that would lead to a lot of problems. And on the other side, you have the industry saying everybody's a bunch of pirates and a bunch of thieving jerks, and we need to throw them all in jail and fine them as much money as possible and go back to the old business model. And that obviously is untenable as well. So striking a middle ground and saying, hey, wait a minute, if an individual downloads a song, it's wrong, but it's not $1 million wrong. It's $50 wrong. It seems like a reasonable place to have a discussion. Unfortunately, like speed limits, it's the kind of thing that you're going to see continually people violating because it doesn't fit human behavior. We have speed limits partially to protect safety because it does slow people down overall, but we also have speed limits to raise money for the county, because everybody knows that there's hardly anybody going the speed limit out there, so you can selectively enforce it. Maybe that's the best we can hope for, but my thought is we need a Copernican revolution here. The idea of continually modifying copyright law, which was developed to address the printing press and the new challenges it created. We didn't need copyright law when it was very difficult to create copies. Now isn't up to the challenge of infinitely copyable media. And I think we need to turn the whole thing on its head.
I think with the speeding limit analogy, let me just say one practical thing. I think when you talk about a 55-mile-an-hour speed limit, and I know that's not everywhere, but let me use that as an example. You don't have a speed limit to keep people from going 65, because people go 65. You have a speed limit to keep people from going 85. And I think that's what copyright law ought to do. The idea that people are copying CDs for their friends, you know, when people were copying CDs for their friends, the industry thrived. I think that was never a huge problem. The idea is to prevent mass distribution, because mass distribution drives prices down in a way that casual distribution doesn't. The other thing is when you talk about harm, if you look at all the studies together, I think I'm getting the numbers a little wrong. There's been about 22 studies, and I think 19 of them, this is about the music business, 19 of them found that file sharing harmed record sales, but they all disagreed about the amount. One thing that's important is you have to understand that, copyright is a right. So on one hand, I don't think copyright is beggaring many people. I don't think the level of infringement is nearly as horrible as the record business makes it out to be. I think they tend to be a little hysterical. On the other hand, the idea that I have to prove a certain amount of suffering in order to protect my rights seems contrary to other areas of the law. Copyright is a human right. It's a fundamental right in the EU. It's in the Constitution in the US. I have that right. Now, it's neither practical nor desirable for me to enforce that absolutely. I get that. I don't want to enforce it absolutely. I'm not sure it would be good for me. But the idea that I have to go out and go to court and prove that someone did $46 worth of damage, I think takes away the principle that it is a right. And that would also be unfortunate.
I think that when I say answering with harm, it's not about dollars. Copyright doesn't exist to create a business. Copyright exists to encourage creativity. And we should look at how is copyright – I am talking about the United States. Good point. Okay. I think we should look at how copyright is affecting creativity and adjust accordingly. If you can build a business on that, that's great. But that is a secondary effect. It's meant to actually create the incentive to create art.
Correct.
Absolutely. And in fact, what I'd like to pick up on what Tom is saying in a couple of ways. First of all, one of the great things about what you just said earlier, Robert, is that I like the way that you helped to make the argument for me. Because if anyone listening to this is sitting down and actually believing that, in using the record company example, that this is purely about the choice, and this is simply the reason why we have so many artists who have been cheated, blindsided, absolutely exploited. It's simply because they were just too stupid to make the right type of choices, because they had poor, idiotic lawyers who didn't know how to represent them, and that the kind of benevolent, generous, God-fearing record companies have absolutely no responsibility whatsoever in this atrocity. I love it when people make those types of arguments, because to a large extent, it enables me to just sit back and be quiet. All right. So since you were so wonderfully condescending to ask me if I knew what an advance is, I feel perfectly comfortable pointing out that through your own description of the process, so much of what you just described is really just a fairy tale crock. And you like to talk about the world of lawyers. Let me correct you on something, because I happen to be a copyright lawyer, and actually, and I know Tom knows this as well. You are not required to prove actual damages when you have a copyright case. Under the copyright statute, you have the option of seeking statutory damages, in which case you don't have to prove. Listen, yeah, exactly. Now, that's something you and I agree on, We agree that the current statutory model is too high. And I know you and I agree on this particular point, because, in fact, you made that point, I thought, rather nicely in your book, that it is true, and this is something that I've written about and thought about, that when the current statutory damage scheme was put in place, what Congress was thinking about is they were thinking about pirates, right? They weren't thinking about unauthorized personal use, and that's where they came up with the statutory damage of $750. So I think all three of us are in agreement that that is one place where copyright law certainly can be tweaked to be more realistic in terms of the current situation in which personal people can do. But I think that one of the things that we have to do, if we're ever going to move forward, right, is that on the content industry side, there has to be a sort of a coming to reality moment to recognize that one of the reasons that there is such incredible pushback against what they perceive to be their interests, it's because of this high-handed, condescending clinging to what they feel are their inalienable right to commercially exploit things that they didn't even really create to begin with, but that they are somehow absolutely entitled to a certain level of outrageous profit. And the day that they begin to accept the fact that the copyright law in the United States is positive social utility law, it inures for the benefit of society as a whole, and their ability to generate profit through their distribution mechanisms is a secondary objective. The day that they accept that and begin to cease making their customers their enemies, then and only then will we finally be able to move forward in a way that will satisfy all of the copyright constituencies.
I think that's a reasonable argument, but you have to remember that copyright is more than a positive social utility. It's, and I quote, the framers intended it to be the engine of free expression. That's Sandra Day O'Connor. The idea that there's a market for copyright, whether it's by creators or their assignees, if you will, I think that's the right term, is something that the courts have very much endorsed. And when you say that there's creators and there's distributors, I think the difference is sometimes a bit vaguer than you'd make it out to be. I mean, you say that these contracts are terrible, but I feel like, there's a difference there's a very fine line between saying these contracts are terrible and I think being a little patronizing toward creators that, you couldn't possibly understand a contract well enough to sign it. I mean, I got a contract from Random House. I read the contract. I chose to sign it. That gives them a lot of rights. Maybe it was a good contract. Maybe it was a bad contract. Maybe I'll regret signing it. Right now, I certainly don't. And it's very hard to argue that I was taken advantage of. I had an agent read it. I had a good agent. I had a lawyer read it. I read it myself. And, I'm not an attorney, but I can read. And, I chose to sign it. A lot of artists like these contracts. And when you say that, when you cast distributors against artists, there's a lot of artists who have problems with their distributors, but there's a lot of artists who don't. When you say, hey, my publisher is Random House, it's part of Bertelsmann. When you say Bertelsmann has to stop making enemies of its customers, Bertelsmann gave me an advance. And when you talk about advances, you talk about proving harm. Advances for books are down about 25% in the last few years. That's harm. You don't see that, are authors making as much on the back end? I don't know. But those advances are going down. You talk about directors and artists not making money later. It's not only the money you make later. Advances are going down. I wasn't being condescending with advances. You were the one who said artists don't see a dime. Well, that's factually, absolutely, entirely incorrect. They do. They get an advance. Sometimes they get money later. Sometimes they don't. There's always problems in a contractual relationship. I'm not excusing the behavior of the record industry. And I also want to turn this a bit. The record industry is a bunch of, generally business people. They want to make money. But there's also business people on the other side. Google and YouTube are not charities. Google and YouTube lobby just as much as the record companies. A lot of lawyers who argue against copyright get funding from Google. I believe they even give some funding to your institution. Is that not correct?
Does who give what to Howard?
To your institution, Google gives money, I believe. It says so on your website.
Oh, we get support from all kinds of institutions. Microsoft on the content side. Yeah, of course, all kinds of. We're an institution that takes support from all kinds of entities. Some of the entities that you would that you would support. So yeah, absolutely.
Sure.
Okay. So there are a couple of
they're not charities. There was companies on both sides. Corporate interests are on both sides.
I never said that companies were bad. I never said that making profit was bad. Okay. And yeah, if what you want to do is you want to say that my statement that the artist never receives a dime, that technically that is not true, I will concede that because I'm very happy to stand up and to acknowledge that, if I produce a product and ultimately that product generates $1,000, but I saw an advance of $2, If somebody later on wants to turn around and say that's the argument that defends the fact that you actually made money off of that, I'm fine to let that argument stand on its own.
I would say you need to fire your agent. You shouldn't have signed the contract.
Okay, I do want to go deep on Hollywood business models and whether they need to be propped up or not. But since, Robert, you raised the issue of tech companies and their interests as far as enforcement and application of copyright law goes, there are two areas in your book that you hone in on as being very pro-technology. And you spend a lot of time talking about the development and enactment of the DMCA and also the Sony Betamax case from the Supreme Court. Those two aspects, number one, the safe harbors of the DMCA, and number two, this notion under Supreme Court precedent that if a technology is capable of uses that are not infringing, substantially not infringing, even if they are supporting infringing uses as well, we need to be giving the technology the chance to continue. We need to support innovation, and infringement may be a byproduct of that. So one of the things that you argue pretty strenuously in your book, Robert, is that the DMCA safe harbors encourage folks like YouTube and others who host content online to turn a blind eye to infringement. I don't necessarily agree with that, and I'm wondering what Professor Mtima's take on that is.
Yeah, I certainly don't agree with that. I mean, I think what the DMCA really was intended to do was to recognize the fact that we have a new order of technology today. That when we used to think about contributory and vicarious infringement, what we were looking at, for example, the Xerox machine, right? And in order for someone to engage in unauthorized copying using a Xerox machine, right, a human being would have to run that machine. All right. So we weren't going to allow the person who owned the Xerox machine to say, I have no responsibility, whatsoever, even though I'm handing over the keys to the Xerox machine. And in fact, I'm picking up, a nickel back in those days. And ultimately, it was more like 50 cents for each page that this person copies. And then to put on a blindfold and say, I have nothing to do with this. OK. But with the advent of digital information technology and the internet, we had a new order of technology that became available. Now it became possible that someone could engage in what was technically considered an authorized copy, right? Meaning I just posted this document, or I just sent this document from me to somebody else. Intermittent copies are made, or in cases of post, intermittent copies are put up. And the guy who in the old days had the key to the Xerox machine, okay, is now the ISP, and there is no key involved, right? They're just, this is non-volitional copying and dissemination. And if what you're going to do, if you're going to hold the ISP to the same standard as the guy who runs the Xerox machine, then the internet is not going to be able to function, because what it would require for the ISP to sit on virtually every single communication, okay, from posts to simple emails, because copyright protection, it's automatic upon fixation. I write a simple email letter and I send that to someone. I post a statement, okay. All of that is copyright protection. So it would mean that before anything could be disseminated on the internet, no matter how simple, no matter for what purpose, right? If we didn't adjust the system in the DMCA to provide for the safe harbors, nothing would be able to move, right? And simple communications would grind to a halt until an ISP, backed up by a battery of lawyers, was able to assess that situation and determine whether or not this document, even if it's just a few sentences, okay, was protected by copyright. And if it could anyway possibly be, do we have all of the authorizations in place to say that it is fine to send this along? So that's all that the DMCA did. It sort of brought the law into focus with the reality of this new kind of technology and made it possible for people to post, for people to send material, for ISPs to allow that stuff to go through, and then for the ISP to turn around and to engage in that checking function only after someone has brought it to the ISP's attention and said, hey, listen, okay, that's copyrighted material. It belongs to me. Take it down. And one of the things that I think that the takedown procedure gave to the content owners is to basically say, hey, the minute that I send that notice, now it's on you, ISP, to take it down. And in most cases, the ISPs, they don't do any sort of like extensive check or exam. They just say, okay, fine. You say it's yours, great, it comes down. And it stays down unless the poster or someone else gets back to the ISP and says, oh, wait, no, actually, that's wrong. Okay, so it's a pretty balanced and fair mechanism that, you know, it allows internet communication and dissemination to take place. But once there is a problem, the ISP automatically has to take it down. And of course, there are some cases in which the ISP takes material down and then later on finds out that it wasn't infringing material and it needed to go back up, you know, after all. So, you know, there's a little bit of a problem for everybody, but it was a pretty fair compromise.
Robert, do you want to go ahead?
Yeah, that's a very good description of the intention of the DMCA. I agree with the intention of the DMCA. You know, when you talk about things getting, you know, every time you use your computer, I'm sorry, there's a word for that, and it's not on the top of my head right now. I'm sorry. And when you talk about ISPs, that's very much how it was meant to function. There's also something in the DMCA where it says you're not entitled to that safe harbor if all. The question is, if you're running YouTube and you look at your 10 most popular videos, so 5 of them are clips from South Park, do you have any duty to filter? So, you know, people say, well, do you think YouTube should go through everything on YouTube? No, I don't think YouTube should go through everything on YouTube. I think some people do believe that. I think that's an extreme example. So should do nothing is also kind of pushing it. I think YouTube should act the knowledge that comes to their attention and not deliberately turn a blind eye. So if you're YouTube, and this is all in the past because YouTube now filters. If you're YouTube view most popular videos, and 5 of them are from South Park, and you know you don't have permission for South Park, it's not unreasonable to say that you want to take action and block those. Now, someone at Google said to me, there's no way YouTube could function if you required filtering. And my response was, wait a minute, don't you have filtering now? And they said, yeah, but that's different. And just so we're remembering, very important to remember, you know, I think YouTube has a lot of positive social functions. I like it. Let's also remember that it's not totally about free expression. 9 of the top 10 most popular videos in YouTube history are major label music videos. I'm not sure there's any positive social function to that, but I guess it depends how much you like Justin Bieber. I'm down on the side of I'm not a believer.
I think it's more Psy now in Gangnam Style, but you know.
Fair enough. I'm behind. But the other thing is to remember, you know, Larry Page, when he was deposed in the Viacom case, said he didn't remember whether or not he favored buying YouTube. He didn't remember whether or not he favored buying YouTube. Now, you know, it's possible he just had a memory lapse. He's a young guy. He seems pretty smart. It seems like a lot to swallow. And then you have the Pirate Bay. How much knowledge do they have? So the Supreme Court in the Grokster case basically said, are you inducing infringement? And I think that was a good decision because it separated technologies that are under your control from machines that you make and then leave alone, i.e. the VCR. It's not under your control. It's not a service. It's an object. And it also said, we're going to look at your intention as well as your result. And I think that's really fair because I don't think, you know, does the Pirate Bay have a use other than piracy? Probably. Is the intention piracy? Definitely. And I think it's very important to set the difference between the Pirate Bay and YouTube, which is now behaving, I think, very well, and other legitimate services. I think it's important to set a difference between what's legitimate conduct and what's not, because that way you're going to have, not only are you going to have better results for creators, but you're going to have fewer lawsuits because people know what they have to do to stay on the right side of the law.
Well, yes
Okay,
and no. I mean, I've lost an entire episode of Tech News Today from YouTube because we made fair use of a piece of material owned by someone else that Universal decided they were going to claim because they didn't want people to see it. It was that mega upload video from December. We were doing a news story about it. We showed a very small clip of it, and we got our whole show pulled down off of YouTube. The most frustrating procedure I've ever been through in my life. I put a dispute right away. The video went back up. Then Universal went and put another dispute on it, and it went down for 10 days. For a daily news show, that's death. For to be gone for what's that?
That wasn't the DMCA.
That was exactly right. That is not that. The second part of that was not the DMCA. That's YouTube's position, and what the reason YouTube's taking that position is they're trying to make nice with the record industry, with the music and movie industry, and they're trying to behave better and negotiate deals so they can rent this stuff out. And I think that's fine. My problem isn't with any of that in particular. My problem is with this entire way that started with the DMCA of trying to replicate physical media protections in the digital space. It just doesn't make any sense. We don't actually require people to take down their singing of a song. That would be silly. If I'm outdoors singing a song and it's a performance and I'm making money on it, there's a mechanical royalty you pay because that's what makes sense. So we need to come up with something that is actually more like that for taking care of copyrights and payments than trying to say, well, these are copies, so let's treat them like physical copies. There's way too many copies. And with YouTube trying to go in and say, well, let's come up with a better filtering system, it ends up with stuff like poor Cody Jackson, who start programming with Python book he gives away for free as a torrent, but because he linked to the torrent, Google took down his ads. Because, again, they're trying to show that they're fighting piracy. And yeah, most of the time they are. And you're right, Robert. These companies lost the high ground in the early days because they knew they were building a business that was largely devoted to infringing content, but they also knew they had the DMCA as cover. And so they didn't start figuring this out from the beginning. They waited until they were forced against the wall. And so we're all stuck with this kind of cobbled together method that I don't think is good for anybody.
Well, let me just correct you on one point, and it's pretty minor. The takedown of the mega upload video in particular was not under the DMCA. It was a private contractual relationship between Universal and YouTube. Now, I happen to think that contract may have been ill-advised from either side. I'm not sure that contract serves the interests of the public, but it's important for principle's sake to separate that contract from copyright law. Neither Universal nor YouTube is compelled to act in the public interest, and I'm not sure they should be expected to. I think it's unfortunate that they don't. I think everyone ought to act in the public interest, but it's not that kind of world. So let's just separate that out for a second. The second thing is I agree with you. I think it's also important, this is not a legal theory. It's sort of something I made up, so bear with me. I'm not sure if you're all attorneys or just one of you, but it's important to separate between what I think of as creative infringement, consumptive infringement, and commercial infringement. Creative infringement is incorporating a work in another work. Whether or not it's fair use, you're using it, and only the court can decide that. You're using it in some kind of creative way that could have a positive social function or at least a good outcome. Consumptive infringement is, I'm not making a new work. I'm downloading it just to watch it, see it, read it, and I don't want to pay for it. That's the first. There are free speech effects on that. It's important. The second, I think it's not protected, shouldn't be protected by free speech. It's less bad. It should be a speeding ticket. The third thing is commercial infringement, where you have Kim.com, who already has a criminal record, running Pirate Bay. And that's important because that's who those high statutory damages were intended for. And while I think that downloading should be a speeding ticket, I don't think running Pirate Bay should be a speeding ticket. I think companies should be able to sue companies for large amounts of money. I'm not necessarily in favor of it, but I don't think that we need to stop it. I do think we need to protect the ordinary consumer. I'm not sure we need to protect that person. And I think there's a big difference between, hey, YouTube and rights holders ought to be able to get together and say, hey, there's a difference between consumptive infringement, creative infringement, and commercial infringement. And by the way, when I talk to rights holders, not a lot of them are that bothered by creative infringement. Are they willing to toss it aside as collateral damage because they're so greedy? Perhaps. But they don't seem to want stop it. I think as filters get better, you'll see more and more freedom for that stuff, partly because copyright holders don't want a bad rap for taking stuff down. And I think that's great. I mean, they should have a bad rap for issuing takedowns for no reason. And, they should stop for that reason. I don't think that's going to be a problem forever. But you're right, YouTube did jump into this. Part of the fault is there because they did build a business based on infringement.
So as we went through in your book, you do go through the whole history of Napster and what happened in the legal proceedings there and the business models that sprung up after Napster to respond to that. And somewhere along the line, we got to BitTorrent. Interesting stat here in our discussion points for the show, coming to us from Music Metric via Torrent Freak. And that is 400 of the 405 million music releases downloaded using BitTorrent in 2012, 124.2 million of them were legal and authorized downloads. So this gets to my point about substantial non-infringing uses and whether there's still a role for that principle in our law. Robert, do you agree that 124 out of 405 million are pretty substantial?
I don't think that's the right. Well, first of all, I'm a little skeptical of statistics from Torrent Freak. Secondly, I'm not sure that's the right way to look at it.
They're reporting them. They come from Music Metric, whatever that may be.
Okay, I'm more inclined to trust Music Metric. And I should add, I enjoy Torrent Freak. I don't necessarily agree with them. I like reading it. I think there's different ways to look at statistics. And if you look at the files, all the files on BitTorrent, and you look at what's infringing and what's not, you're going to see a lot of non-infringing files because the amount of files on BitTorrent approaches the infinite. If you look at it by who's downloading what, you get very different results. Look at the top 100 on Pirate Bay. You'll see Drake, Lady Gaga, Justin Bieber. The most popular stuff to download on BitTorrent is copyrighted. So then if you look at BitTorrent use and you're trying to figure out how substantial is the use, you can't look at the number of files that are theoretically possible to download. You have to look at the use. How is it actually being used? And the way it's actually being used is for piracy.
Well, so that gets back to your distinction between creative consumptive and commercial infringement?
Okay, so I think the people running Pirate Bay, they're criminals under the laws of most continental European countries. They're committing, I would call commercial infringement. That's my word for it. I think it's a clarifying term, but it's not a legal term. And I think they should be subject to substantial penalties. People who are downloading from Pirate Bay are committing what I would call consumptive infringement, or most of them. They just want to listen to something, watch something, read something without paying for it. I don't think that's a really big deal. I think it should be punished by a speeding ticket type of penalty. Mm-hmm. But I also don't think, some people believe that it's, I've heard some people tell me that, Pirate Bay is really a social good. Well, last year, the most popular illegal download on BitTorrent systems was Fast 5, which is the 5th movie in the Fast and Furious series. And although I think that every, movie studios do have rights, much as some of them aren't my favorite people, and you are violating their rights when you download it illegally, I don't think it's reasonable. Well, I haven't seen it, so I can't say that it's a bad movie, but it seems reasonable to believe that it's not I don't think it's a fundamental necessity of citizenship to watch Fast 5.
Well, but that argument cuts both ways. You may say then we don't need copyright laws to protect the creative expression of making Fast 5, too.
Oh, of course we do. We need the intent of copyright. One thing that I feel very strongly about is that I don't want copyright to protect only what someone considers worthy expression. Because the problem is who gets to consider what's worthy expression. And that's one thing I objected to when Lateef wrote about my book, is that I feel like, and maybe I was unclear, so I don't want to cry foul, maybe I was unclear, is that I feel like he made me sound like a bit of a snob. I want copyright to protect AC/DC. I want copyright to protect Grand Theft Auto. I want copyright to protect NWA. Partly because that's what I like. I'm not a very advanced. I'm not a person of a very advanced aesthetics, but partly because I don't want the government to make those decisions. And look, as far as Fast Five being in the market, I think that's great. It employed a lot of people. They bought a lot of cars to blow up, which probably employed more people. People lined up to watch that movie. God help them, but people lined up to watch the movie. That's all great. My only issue is people say that Pirate Bay is absolutely an essential thing. I sort of lose it there because I don't think that it's a right. I don't think it's some kind of right for everybody to have the Drake album or for everyone to see Fast Five. I don't think that's right. But I think
no. But what I do think is a right. Sorry,
I don't want the government deciding. In 1989, the government could have decided, hey, we don't want NWA to have copyright. And this is exactly what free speech was in to protect: unpopular, politically charged expression. And I would say, there's a lot of creative infringement issues with hip-hop, and I think we need to allow more leeway to sampling. I think that's really important. But it's also important to remember, Dr. Dre, who was in NWA, was the second musician to sue Napster after Metallica. He said, and I'm not quoting, but he said, I don't want them stealing from me. Dr. Dre, even though he would love to sample for free, it was important to him to get paid. And that's sort of the use of copyright, is it gives people like that an incentive to make art that, NWA is not going to get funded by the government. You want people like that to have an incentive to make art, even though it's not comfortable, even challenging. This is important art, and I think, 20 years later, it's recognized as such, at least in my stereo.
Well, the question that I was bringing up earlier is what kind of copyright law encourages the highest amount of creativity? And how much are infringing uses encouraging creativity, and how much are they discouraging creativity? And not just creativity, but high-level creativity. And that's what no one ever talks about. It's always talked about in dollars and cents. Dollars and cents are great, and they should come, because what dollars and cents do is encourage creativity. But I feel like we need to back it up a little bit from just talking about the business side. You build the business off the creativity. What laws actually give you the best chance of being creative? It's definitely not the laws we have now.
Right. Yeah, and I think, when we get into talking about BitTorrent and technologies that enable distribution in ways that have not been conventionally the case, we have to be careful that the same copyright that incents creators does not also then toss those new distribution methods out the window, which is why I am concerned for the future of technologies like BitTorrent if we're going to take substantial non-infringing use right out of the equation. What do you think, Professor Mtima?
Yeah, I think that's absolutely right. In fact, here's a place where a couple of things that I'm going to say. Some things I get to agree with Robert on, and some things I get to agree with Tom on. First off, just by way of a footnote, I know you're not a lawyer, Robert, but you'd be pleased to know that the sort of categories that you've come up, there's been a lot of legal scholarship written about uses of copyrighted material that divides things up in just that same way. In fact, some of them use the same labels, so you're on the right track. And
I should have said I've taken those labels. They're not. I adjusted them a bit. I should have said I stand on I'm inspired by people, certainly.
Okay, yeah. So it's definitely good stuff. I think that in terms of one thing that you said in there that I definitely agree with, and I think is definitely the way that we need to go, and that is that we do need to make a distinction between the Pirate Bays of the world and lots of other kinds of unauthorized uses. So I think you and I are 100% agreement on that, because I think that for some players in the content industry, in some circumstances, sometimes they fail to make that distinction, right? And I think that, when you've got somebody out there who's just running a website in Russia and they're just, getting a copy of a movie and selling it to whomever they can, that's a problem. And obviously that's a very different type of problem. But that also leads into the point that you were making, that Denise was making on the other side, about, so what do we do? Do we blame the technology? And one of the problems that I have with that, and one of the problems that I have with the methodology that you were suggesting, well, let's look to see how BitTorrent is actually being used as opposed to taking into consideration its full potential. In a way, that's kind of like deciding whether or not we should outlaw fire, right around the time of the Great Chicago Fire. I mean, if that's the only thing that we're going to focus in on, all right, well, then maybe we outlaw fire. But if we sit down and we recognize that, well, what can this technology be used for? And I think that the statistic that Denise pointed to points to the same type of problem, or rather the same types of consideration that enabled the Sony case to be decided the way that it was decided. It was like, yeah, sure. We see what this technology can be used for. And one of the things it can be used for is piracy. It can be used for illegal misappropriation of content. But it also has some other extremely beneficial uses, particularly beneficial to the copyright objective. So what we have to do is we have to figure out, how do we encourage the development of this technology? How do we encourage the use of this technology for all purposes, including copyright beneficial purposes? And then when it comes to those people who misuse the technology, it makes much more sense if we come up with more precise regulation that's narrowly tailored to deal with that problem, which is really the problem that I don't think anybody disagrees with. That, okay, if you want to go after those guys, that's fine, because those types of problems, they don't really implicate, any genuine fair use concerns. They don't implicate any genuine user-generated content fair use concerns. And I think that, what we can all agree on is that if we stay away from those extremes, and we isolate the bad guys, and we realize that there's a lot of gray in the middle, okay, and that the impact of that gray is to get back to something that Tom was talking about. Hey, when do we think about the gray and the way the law is to regulate the gray in such a way that it actually encourages creativity? Because one of the other things that I often take issue with is that, again, a lot of people who are in the culture business, okay, in the culture of business as opposed to in culture, okay, they oftentimes make the mistake of thinking about only the secular incentives to create. And, there was a wonderful play back on Broadway back in the 1970s, around the time when there was a lot of focus on African-American urban culture and expression. And it was called Mama, I Gotta Sing. And the title alone tells you that the incentive there was not a secular dollars and cents incentive. And, whether you're a Gauguin or a Van Gogh and going to cut off your ear because you have to paint, there's a lot of creativity that's going to happen nonetheless. And we want to make certain that our copyright laws and our other IP laws encourage that type of creativity, as well as the type of innovative endeavor that leads to new technologies and new technological uses as well.
Okay, I think that's a great place to take a break, because I do want to get to the motivations and business models that involve distribution of copyrighted material. But we do need to thank our sponsor for this episode of This Week in Law. We've been having a feisty discussion with Professor Lateef Mtima from Howard University, Robert Levine, author of Free Ride, Tom Merritt, and me. And we're doing that through the good graces of ShareFile. When we're working, we need a professional, easy, and secure way to send and receive large files, share documents and other materials with clients and colleagues to increase productivity and get things done. That's why I highly recommend ShareFile by Citrix. It's the tool that millions of professionals rely on every day. ShareFile is a sharing solution for business that is easy to set up, easy to use, and completely under your control. Files can be password protected and time limited. You can see when they've been received and modified, and files can be accessed from anywhere, any Mac or PC, tablet, or smartphone. I use ShareFile in my law practice all the time. It's the perfect way to make sure that attachments to emails don't get bounced back, because it doesn't work as an attachment to email. People access the files directly on the web from a link. All my confidential files and contracts get shared that way. My team has integrated ShareFile whenever they can, and that's how we make sure that clients get the best possible access to what we need them to be reviewing. So I want you to try ShareFile with my special offer. Sign up today and receive a 30-day free trial. Go to sharefile.com, click the radio microphone, and enter TWiL. Remember, visit sharefile.com and type in TWiL. And with that, we've been talking all around Hollywood, but let's get right to it and talk about its business models. Okay, Robert, I've got to say that the one thing I kept finding myself responding with as I was reading your book is the fact that the business models you are a fan of, the author signing the book contract, the recording artist signing the music contract, are all the way that Hollywood has traditionally done business. And what we are finding in this decade is that those means, and we can chalk it up to piracy, we can chalk it up to the economy, we can have all kinds of talks about why Hollywood has not been doing as well as it has historically done. But those business models haven't been working so well for whatever reason. Now, what does that mean? Does that mean that Hollywood should be bailed out a la the financial institutions or General Motors? I come down on the side of no. I come down on the side that it's a question of competition.
You talked about bailing out and propping up Hollywood. That's technically inaccurate.
Okay.
So copyright is a right. It accrues to creators. Creators can sign it away contractually. So we're talking about enforcing the law. Now, it is absolutely perfectly reasonable to argue with me that I want the law enforced too much or that my priorities are wrong. I would agree that copyright lasts too long. You could say that we don't need it. That's certainly reasonable. But to say that enforcing the law equals bailing out or propping up is legally inaccurate. I'm not saying that I'm right, but just when you say propping up or bailing out, you have to be very careful because we're talking about how much to enforce existing rights, not adding rights. The second thing is, there's business models I'm a fan of, but there's business models I'm not a fan of. I'm a fan of willing partners buying and selling, entering into contractual relationships by choice. So when you talk about, do I want to see a movie in the theater? Do I want to see it on DVD? Do I want to download it? Do I want to stream it from Netflix? I think any of those are great because they're legitimate options that bring money to the creators and in some cases to the studios that'll let them invest in more creators. Let them give creators more money. Some of those movies are great. Look, I'm not going to defend Fast Five or the Transformers on an artistic level, but copyright protects them for a reason because we want it to be a market. I don't want the government getting that involved in art and speech. Now, so as far as distribution, I'm pretty neutral. I just favor legitimate relationships. As far as business models, I think that the idea of giving creators in advance is really important because, you said earlier that those companies are in the distribution business. I think they're actually in the business of aggregating risk. I'm sorry if that sounds pretentious. I know it does. But when you think about what studios are really good at, what record companies are really good at, they're not really that good at getting stuff to stores or theaters because that's not really that complicated. It hasn't been for a long, long time. When you think about what the internet does well, it gets stuff to people much better. But what those entertainment companies really do well is they aggregate risk. And what that means is, Random House is going to sign a bunch of books, maybe 50 books this year, and maybe 1 out of 8 is going to make money. These numbers aren't exact, but the book business, the movie business, the music business, these are all really risky businesses. So the reason these, I'm getting a $4 royalty on each hardcover when the hardcover is about, I think, $28. The reason that royalty seems really low is because out of every 8 books that they sign and give an advance to, 7 of them are going to lose money. Now, what I like about copyright is that who's best qualified to take that risk? A journalist who's never made a whole lot of money, i.e. myself, or a multinational conglomerate who can publish 50 books a year, pool that risk, and end up at the end of the year making a profit. Not a huge profit, but a profit. I think the multinational conglomerate is best suited to take the risk. So what I like about my relationship with Random House, and it is in some ways it's a very comfortable relationship. I like my editor. I like my publicist. In some ways, it's an adversarial relationship. I want to make more money. They wish I had finished the damn thing a lot earlier. But what's great about this relationship is that they take the risk. They give me money in advance. Maybe I could have made more money later, but I didn't want more money later. I wanted money to live on now. So that part of the traditional relationship I like. The part in terms of how it's distributed, I'm pretty neutral on. As far as business models, there's only one business model in the world. Selling something for more than it costs you to make or buy. In some cases, you're selling ad time. In some cases, you're selling services. In some cases, you're selling physical stuff. In some cases, you're selling virtual stuff. But that's the only model. There is no other model. So when you talk about the Pirate Bay as a model, that's not a model. Because they're not.
No, but BitTorrent is.
Stuff. Well, BitTorrent is a distribution model. BitTorrent can be a very efficient way to distribute stuff. It's just that BitTorrent replaces a truck. A truck is inefficient, BitTorrent is efficient. BitTorrent doesn't give anyone an advance. And when you talk about, look, there's good BitTorrent trackers and bad BitTorrent trackers. So I don't think we should make technology illegal. I don't think Congress has the power to make technology illegal. When you talk about the example of the Chicago fire, would Congress have made fire illegal? I can't imagine how they would do that. But could they have passed a law that says if you have a cow next to a bucket of, gasoline and a lantern, and the cow kicks it over, you could have civil liability for leaving the cow close to the lantern. This is a bad example, I'm sorry.
The O'Learys dispute the accuracy of that story still, but that's a separate point.
Sorry. I can't I'm kidding.
But Robert, here's my problem, is that for the first time in my lifetime, as we look at the internet today, I see actual legitimate competition to the traditional Hollywood way of doing business, aggregating risk, as you say, and distributing things. And yes, things need to have a price, and creators need to be paid. But what I don't agree with is that there's any reason that the advanced system, the studio system, the SAG-AFTRA system, all of this that we just sort of take as a given, that's the way things should be. And what the internet has done, as far as I'm concerned, is disintermediate and disrupt all that. Look at our network. Here we are. We're not affiliated with anybody but ourselves. Our founder, Leo Laporte, got fed up with what he was doing on television and decided to go out on his own. And thanks to the internet, he can. And here we are. So I think that. Go ahead.
I support is SAG-AFTRA because I'm a supporter of organized labor, and I think that's very important. Mm-hmm. The other things I could take or leave. I don't want to prevent you from publishing a book. I want to prevent you from publishing my book. So when you talk about the Pirate Bay isn't a business model because they're not paying for what they're distributing. The Pirate Bay is, free riding, if you'll forgive the implicit endorsement for my book. Pirate Bay is free riding on the investments of others. Hollywood invests millions of dollars in movies, whether you think they should or they shouldn't is beside the point. The Pirate Bay takes advantage of that investment without paying for it. So that's not really a functioning business. Can your business be a functioning business? I don't know enough about it, but I certainly hope so. I think that's great. To the extent that, YouTube, let me give you this example. YouTube just started paying creators advances. That's a great thing. I think that's potential of what the internet could be. Now, some people will say that YouTube, the good people at YouTube sat around and they said, what can we do for the world that's great? Let's give artists money. We're charitable, good-hearted people. I would suggest if you believe that, you don't understand American capitalism. The other possibility is YouTube said, hey, wait a minute. We have to have more legitimate content. We have to compete. We have to compete with Netflix. We have to compete with iTunes. We better give artists money. Because I take issue, when you look at competition, who's really not competing here? There's a lot of studios, a lot of independent companies, a lot of creators who are investing a lot of money in movies. There's a lot of major label artists, a lot of indie label artists, a lot of independent artists who are making music. There's a lot of writers who are writing books. I consider myself independent because I don't have health insurance, but I'm published by a major publisher. Who's not competing here? To me, the Pirate Bay is not competing. What music have they made? What music have they funded? Whose permission do they have? So you tell me here, who's really not competing? I understand that the studios and the labels are dislikable people. Many of them are dislikable. I dislike some of the people that work there. I won't tell you who, but I do. They're not cuddly. I don't dispute that. The BitTorrent people seem cooler. They do seem cooler. They probably have better parties, but that's not the point. The point is that BitTorrent doesn't do a very good job of funding stuff. I would say they're not competing. To the extent that they are competing, they're taking advantage of the work of others in order to compete. I guess you could say they are competing, but they're competing unfairly. What I want is fair competition. I welcome competition. If you want to write your book and put it up against my book, that's awesome. It's going to make me a better writer. If you want to sell your book for $1 and I'm still selling my book for $30, that's my problem. Hopefully people like my book. If
well,
not,
it's not your problem if the publisher is setting the price. If the publisher is getting together behind closed doors with other publishers and Apple, for example, and deciding we need to have prices that are going to enable us to continue paying these advances to writers, and our entire business model as it traditionally has existed cannot support, $11.99 ebook pricing. So we need to have something higher. I'm saying that's just ignoring and not having competition.
That's well out of. Let me put that aside for a second because that's well out of copyright, and it's also, you'll have to pardon me. I know a bit about the book business. I can discuss the book business intelligently, but antitrust law and collusion and the stuff you're talking about is really, as a non-lawyer, it's a bit beyond me. I will say that no one's gone on trial there. We don't know what happened. I'm waiting to see. That some publishers settled, but we don't know what happened. But I don't mind the idea that someone else is selling a book cheaper. That's great. That's my problem. I believe that my book is worth more. We'll see if I'm right. It makes me nervous, but so do a lot of things. I think I'll be fine. What I object to is someone else publishing my book who doesn't have the right to. That's the heart of my objection. The stuff about Amazon is a bit to the side. I'm happy to talk about that. But the essence of what I'm objecting to is someone else publishing my book without my permission. That's the essence of what we're talking about. And I think that if you look at Pirate Bay, if you take away the copyrighted work from Pirate Bay, what you're left with is really kind of nothing.
Yeah. Well,
all right, so there's one point on which we all seem to agree, and that is that the culture business is one in which it is hard to make money. And we have actually someone from YouTube who wants to weigh in on that point queued up, I think.
Hey folks, what's happening? It's Todd here, and I'm about to show you the hardest thing that you could do on the guitar. Now there's a lot of guitar players out on YouTube. A lot of them are really good, but most of them can't do this one thing. So I'm about to show you the hardest thing that you can do on the guitar. You ready? Make actual money.
So a little note of comic relief inserted into the show. Tom, I've been talking too much. What do you think about alternate distribution means, alternate business models from the traditional Hollywood structure? I mean, certainly we see people going out there and using Kickstarter in very innovative ways for their creative works these days. Do we need Hollywood, and does Hollywood need extra help from Washington to be able to continue the way that it has existed until now?
Yeah, I don't think that we need to change the laws for Hollywood in particular. I agree with Robert on that. It's about enforcing copyright law and rationalizing it, making it work for everyone. And I think when you talk about things like Kickstarter and self-publishing, those are excellent things. I've taken advantage of both of them to varying degrees of benefit. And they are extra things in the arsenal that the internet brings us. I don't think Hollywood's going away. I don't think it should go away. I don't think big publishing should go away. As Robert has pointed out, they provide very valuable services. They're very good at certain things, especially marketing, especially negotiation and helping you build an audience. Those things they're experts at, and that a lot of times gets thrown out of the discussion when you're talking about this sort of thing. It's not an either or. We've actually, the internet's been around. We've seen this before. When your eBays and Amazons come along, it doesn't drive Target and JCPenney out of business. It may take away business for a while. They may figure out ways to work with each other or not over time. But eventually, some business models like an Etsy come along and say, hey, we're going to help the small person reach out to a new audience. Some bigger business models are created online like an Amazon. And we have incredibly thriving retail outlets as well. So the dot-com boom didn't kill every single brick and mortar business. And we're going through the same thing with media as well. I think we'll see Kickstarter really change a lot of the landscape and how things get funded and what kinds of things can get created, because individuals can take advantage of some of that upfront money that they wouldn't be able to do without. And I think you'll see Google's and you'll see people move into that middle ground. Netflix is starting to create content, commission content. That's sort of analogous to Amazon and eBay. And Hollywood's going to stick around too, because the best of Hollywood will adapt to this. My biggest problem with this whole conversation is the idea of talking about enforcement in terms of copies and saying things like, well, when you see infringement, you need to acknowledge it and react to it. With millions and millions of infinitely copyable files out there, you can't see it. You have to approach it in an entirely different way. And I'm not even disagreeing with Robert on this point. It's just something we kind of forget when we're trying to use these metaphors. Enforcement means something entirely different on the internet. We wouldn't go around telling people you can't hum that song without permission, right? I mean, that's just ridiculous. It's unenforceable. The internet is even more unenforceable if you approach it that way of like, let's look for every copy that's infringing and go after it. You have to come up with a different way of approaching it. With music publishing, we went after a mechanical royalty and said, we'll send people around, ASCAP and BMI will do logs, and we'll try to get an estimate of what's being played, what's being performed, yes, and we'll do a royalty. I'm not saying mechanical royalties are necessarily the solution, but it needs to be a different approach like that.
I think that could be an interesting approach. I mean, one thing, if you're taking the quote-unquote law of the real world as an analog, let me use it for instance. The law in terms of, and I'm embarrassed I'm in front of lawyers, I might be making a bit of a hash of this, but there's part of the law, and I forget which part of the Copyright Act it is, says a public performance, if you owe ASCAP, BMI, or CSAC royalties, it has to be a public performance. And a public performance is obviously in public, and I think it's outside, the definition is something like outside of a gathering of family and friends or something like that. So if you're humming a song to yourself, no one's going to come after you. Similarly,
I was imagining being outside, but I get what you're saying.
Well, I guess it depends if you're in front of an audience. Look at it that way. So if I set up my own locker myself and I stream my own music collection to myself, I don't think I should have to pay a performance royalty on that. If another company does it for me, if I use Amazon's locker, I think it's more like being at a bar. They are using that music to make money. They should pay a royalty on it. I think it should be a reasonable royalty. But the essence of copyright law, I don't think has as much to do with copies as it does that's a name from the time it was created, but if you think about the history of copyright law, it tends to cover commercial uses. And the reason copyright got in trouble online is I think people started applying it to personal uses, and it doesn't suit those uses well. Copyright law was never meant to come into your house. It was meant to apply to the public. And I think that's how it works well, and that's how it continues to work well. When you start employing it in the private sphere, it doesn't do well because it's just not suited for that. The whole history leads you in very strange directions when you try to bring it into your home, if you will.
Hey, Robert, I have a distribution and consumption question for you. Can we all agree
Sure.
that these just serve no purpose in our lives anymore?
No,
Whether
I
they
use
are
them as
for
coasters.
Music and DVDs. I got these literally at a flea market, not a flea market, like a little antique sale in a church parking lot where a woman had a table full of them just free for the taking. Just, little
Christmas
kids
ornaments.
were walking by, yes, picking up fistfuls of them, which my son did. That, basically, your book talks, the reason I raise it, Robert, is your book talks a lot about falling CD and DVD sales. And I think that's maybe asking the wrong question as far as Hollywood is concerned, because my point is people have no use for these anymore. And what they actually do is eat into digital sales, because to the extent I would ever buy a music CD or a DVD in today's world, I would buy it because maybe I saw it at Starbucks. I would say, I have a friend who likes that. I would bring it home, rip it to my machine, give it to my friend. They would then give it to someone else, give it to someone else. Nobody wants these around it.
What percentage of music business revenue last year do you think came from CD sales?
I don't know. You tell us.
Say again?
Tell us. I don't know.
I think I could be wrong. I think about 45 in the U.S. In Germany, where I live, I think it was about 85. First of all, the music business likes selling CDs because they're very profitable. I like listening to vinyl because it sounds better. But I'm not expecting everyone else to listen to vinyl. I'm not expecting anyone else to listen to vinyl. I like it. It's either an eccentricity or personal flaw, depending on whether or not you're living with me. People who live with me generally see it as it takes up a lot of space. But I think that
it really does.
It's an inconvenient look. What I say is it's cooler than playing golf. In terms of hobbies, it's cooler than playing golf and easier than drinking. But whatever. I think what I used in the book, I didn't use falling CD sales. I used falling music sales because the way Nielsen SoundScan measures, the best statistics you get are sales of music in album equivalents, which is basically 10 iTunes songs put together equals an album. There's different statistics to use. I use those statistics as they're the most accurate statistics. And I used music sales, not CD sales. In terms of DVD sales, I plead guilty to that one. I wrote the book in mostly 2010. And in 2010, the revenue from streaming and downloaded movies was pretty small. That's changed since. If I wrote it today, I would use more modern statistics. But in terms of discs, a lot of people like them. There's a tendency for people like us who think about this stuff to think that we live in a digital-only world. But I think that's a bit of snobbery. A lot of people like buying CDs. Do I like buying CDs? I tend to buy vinyl or stream. Why do people like CDs? It's not for me to say. But
the only reason I can think of is because they live in an area that does not have high-speed internet access.
A lot of people don't have high-speed internet access.
Yeah.
More people have cable. Listen,
and for that,
in the U.S., more people have cable than high-speed internet. Part of the reason is because in some cases it's not available. Part of the reason is because a lot of people like cable better than high-speed internet. I don't. I think high-speed internet is more important. I don't have cable. Well, I guess I have cable in German, so I can't understand it. The game shows are funny. But, I don't think it's for me to say, hey, you buy this, catch up. People,
right.
Walmart sells a ton of CDs. Good for them. If people want it, that's great. I don't want to tell people what to do. As far as the music business goes, they like CDs. They make more money on them. I don't really have a view on that. I think if people are buying it and people are making money and everyone involved is a willing participant, I think that's great. I don't see anything wrong with CDs. I don't know that they're the best way to listen to music, but they might be the best way to listen to music for some people some of the time.
My problem with them is I think that they are actually damaging the industry that you're arguing needs help. That by continuing to cling to that business model, they are losing digital sales that they could be making.
No, because if you think about it, there's a couple reasons that's not true. You could argue that was true 5 years ago. At this point, the customer for digital and the customer for CDs are very different customers. If you look at what sells, there was a great statistic, and I wish I could remember it offhand. The Susan Boyle album, this is going back, I think 2008 or 2009. I think 95% of Susan Boyle albums were sold on CD. And Lil Wayne, this is also a couple years back, I think was 65% digital. It would be higher today. The point is, they're very different customers who want very different things from very different places. I don't think one's a substitute for another. I think a lot of people could buy either. Sometimes the right CD at the right price is a sale. You said when you're in Starbucks waiting online, that's a sale. Sometimes
but
the right
it's a sale. That's a sale that takes sales away from other people, because what I do with CDs when I buy them is I give them away, and then someone else gives them away, and so on and so on.
Yeah.
And because they're not copy protected, each one of those people can put a copy on whatever device they would like.
But you can do the
before
same
they
with
pass it
iTunes.
along.
You can download an iTunes. You can download a file from Amazon and do the same thing. I mean, Amazon sells unprotected MP3s, so I don't see that's not a difference. The other thing is there's some bands, I'm not necessarily saying this is a legal point, but, there's a great piece in the Washington Post that said the Beatles had really screwed up by holding out so long from iTunes. And I thought this is a great example of how most reporters just don't understand the music business. In the last decade, the first decade of the 21st century, the Beatles were the second most popular act, sales-wise, after Eminem. The most popular album of the decade by sales was number one, the Hits Collection by the Beatles. The Beatles sold more albums because they held off from going onto iTunes. They sold fewer songs and more albums, and since albums cost more than songs, they made more money. Should they do that morally? I don't really think it's my business. It's up to the Beatles and in some cases their heirs. Was it a good business decision? Yes, definitely. Meanwhile, I might add, the Washington Post really staked its reputation and its business on free, and the Washington Post is sinking really quickly. Look, different things work for different bands. What I think is important, I'm not going to argue about CDs or vinyl. What I think is that each creator should have the right to decide as much as possible how they want to sell their work. And if that's doing a deal with Kickstarter, that's great. If that's doing a deal with a major label, that's great. Some artists are going to do really well on CDs. Neil Young hates MP3s. He thinks they sound bad. I almost swore. I'm not sure if I'm allowed to. He should have the right to sell music in a high-fidelity format if he wants.
Yeah, did you see his thing on Late Night with David Letterman last night? He introduced his new effort. I think it's called Pono. That wants to deliver high-quality digital. And his argument back in January is like, piracy is like radio. We need to provide people a better thing, a better alternative that's worth paying for. And so he's contracted with all three major labels to do that, apparently.
And when he introduces Pono, I'm going to line up to spend more money on albums that I have already. I'm going to take albums that I have and I'm going to buy them in a higher fidelity format, either because I value art or I'm a total sucker. You can decide which. But it's my choice.
Right.
Well, something that I wanted to just chime in on is, because I'm glad the discussion is moving in the direction of, okay, well, let's think both about the real world and think about some interesting things we can do. First, I think it's very important that we recognize that something that oftentimes gets lost in the discussion is that, when we criticize the old business models, that doesn't mean that we are defending, the piracy business model. I mean, because just as there are obviously a lot of things wrong with rank, outright, uninhibited piracy, of course, there's also some things wrong with the traditional combination of business models and the way in which we interpret the law. I mean, one of the things that I wanted to focus in on was the fact that, it can be a bit of an oversimplification to reduce the infringement, unauthorized use controversy to, hey, there are rights on the books and let's enforce them. because, we always have laws in the books, but at the same time, in the law, we have doctrines that go to questions of contracts of adhesion, meaning contracts that take advantage of the fact that people don't have choice. And we don't allow that in the law. We have doctrines that go to questions of unconscionability. Okay, contracts that are just in no way, shape, or form, any way you look at it, they're just completely unfair and abusive, and we don't allow it. I mean, we actually will void those contracts. We have doctrines in the copyright law of copyright misuse. There are times that you have a copyright, but you're using it in a way that you may think is good for you, but is actually contrary to the reasons as to why we have copyright in the first place. And so one of the things that we have to keep in mind is that there are cases in which rights holders, in part because of the kind of business models that they rely on, there are times that they actually misuse those rights, all right? And I think that that issue arises very much in this new digital information context, because sometimes some.
Did we lose him, Colin? Sounds
He
that
just
way.
Froze, so he may. Oh, no, he dropped.
Oh, dear. Okay, we'll see if you can get him back on so he can
All right, I'll hit you in chat if I do.
finish his thought. Let's move on to our resource of the week, which is a really great legal reference tool called the IT Law Wiki that it seems to be aimed at IT professionals. It has a great section on the DMCA and some of the other things that we've been talking about today on the show. I stumbled across it doing some research myself, so it looks very useful, and I wanted to share it with all of you. I was actually hoping to get Professor Mtima to help out with our tip of the week. Colin, if he's back, we'll do that. Not yet.
Not yet.
Okay. Well, we may have to shelve this one for next week then. Let me know if he comes back on. But in the meantime, a couple of just last points on this very interesting discussion we've been having. Tom, we've been talking a lot about piracy and how it may or may not impact the business of Hollywood. One point I found really interesting, and I know you've talked about this before on frame rate, is Game of Thrones being the most pirated show of the spring season. Now, do you think that there's any correlation, be it positive or negative, as to HBO's business from that? Do you think that harms HBO, or maybe helps it because it increases demand for their wonderful product?
Well, that's the argument, right? Those people who are on the side on one side will say, you know what? The folks who are going and downloading infringing copies and doing consumptive infringement are people who probably wouldn't pay for HBO and are so inconvenienced by the risk of viruses and the reasons that they might have to go through all these hoops to download Game of Thrones, that all it will do is encourage them to go subscribe to HBO. And of course, if you're HBO, you're going to say, no, that maybe not every one of those is a lost sale, but that's lost revenue, and it shouldn't be out there. People should have no choice but to pay to get HBO in order to watch these. The gap there is the fact that there are a growing number, and it's small now, but a growing number of people who don't want to pay for cable, which is the only way to pay for HBO. They will give HBO directly the money, but HBO won't take it unless it comes through a cable company. And I think that we'll see that change over time, and we'll see HBO's already taking an experimental stab at that in the Scandinavian countries with a version that you can get directly over the internet. So I hesitate to come down one side or the other, because I don't want to give someone the idea that, hey, it's okay to go out and do consumptive infringement because you're just helping to popularize the episode, even though socially, when you step back, probably are. You could probably, see that there's a little bit of promotional value to HBO there, but it doesn't change the fact that you're breaking the law when you do it.
Right. Robert, any thoughts on that one?
I think it's even more complicated than that because, you're talking about mostly a primary market, how it affects subscribers to HBO. But if you think about how movies and expensive TV shows are made, not all TV shows, but expensive ones, you get into secondary and tertiary markets. I don't have HBO. I can't get it here, or I can't get it in English. So I downloaded Game of Thrones, the first season, on iTunes when it was available on iTunes. So, HBO and whoever pays for Game of Thrones, I don't think it's only HBO, they're selling subscriptions to HBO. They're selling DVDs. They're selling downloads. At some point, it might be on Netflix. At some point, it might be a rental. In every case with every video product, you're going to have a lot of different income streams. So you could say, well, does this affect the number of people who are going to see it in the theater or subscribe to HBO? Hard to say. But, movies make money. Movie studios make money selling movies to hotels, selling movies to airplanes. There's a lot of income streams that it affects. And I think this is a long way of saying, I don't have an answer. I'm coming down on the side of it has to have some negative effect. Mm-hmm. But I think you have to look at the negative effect, not only in terms of, would these people pay for HBO? Maybe they wouldn't pay for HBO. Maybe they would have downloaded it. You also have, maybe they, it's going to affect the price for foreign rights in Singapore. And, I'm just using that as an example. Maybe it's too much.
The piracy is the butterfly flapping its wings that affects something around the globe.
That's right.
All right, Professor Mtima, I have a tip of the week. I was hoping to get your help with because it is on the theme of free writing. It came from one of our listeners who is, and I'm going to just keep him anonymous here. He knows who he is. Getting ready to launch a daily news podcast centered around local news headlines in his city. He's writing and recording most of the content himself, but sometimes he might want to include sound bites, and these might come from his own on-site recordings of public events or interviews. But most of the time, the local news media, TV, and radio provide the best recordings for use in their own broadcast packages, and he's interested in using those. His podcast will essentially be a news source, and he's acting as a member of the media. Does that mean he's allowed to use those sound bites fairly and legally? He's sort of Huffington Posting here. So what do you think?
Yeah, I mean, that's one for which there's no across the board type of an answer. And at the risk of not knowing what jurisdiction he's in, let me say that this is just an academic response, and I'm not practicing law in jurisdictions that I happen not to be admitted to. But I think the reason why it's not easy to give an across the board answer is because, generally speaking, if you're going to take a little portion of a factual, oriented work, and then you can use it for a newsworthy, critical type of purpose. I mean, that sounds like it couldn't be any closer to the core of fair use than one might imagine. But the caveat, though, is that with the fair use, you have to take into consideration the 4 fair use factors. And, one of those factors is the amount and substantiality of the portion that you're taking. And because we're not talking about print media, we're talking about, audio excerpts from what might be audio and or video telecasts, without being able to view each tiny portion that's being used, there's no way to just say blanketly that all of them, would qualify as fair use, because some of them, the analogy I like to use is that if you take one sentence from a book, it might seem automatically that ought to be considered a fair use. But what if the one sentence that you took happens to be the last sentence of a murder mystery? That's a very different sort of a circumstance. So it sounds as if, given the type of material that he's extracting portions from, given the kind of use that he wants to put it to, and then also, I don't know the answer to this factually, whether or not these podcasts that he's putting together, are they for commercial purposes? Is he going to be making money off of this? Or is this just sort of like a public service type of thing? because that also, is a difference. So it sounds like he's in the right direction. He's getting close to the core, but unless it's a very tiny snippet and, very factual, I hate to say that he needs to sit down with a lawyer and go through, each and every one of these things. But at the same time, I don't want to say that, blanketly without, being able to review each of the individual ones as to whether or not all of them will come under the fair use radar.
All right. Well, we really appreciate your help with that. And I have had such a great time having this great discussion with you all today. I can't thank you enough, Robert, for joining us from Germany and for taking the heat with us here today. We've enjoyed talking with you, and I'm thoroughly going to enjoy reading the rest of your book.
Thank you very much.
And don't forget, folks, it's just now out in paperback. I have the ebook version of your book, which is priced the same on Apple as it is on Amazon.
Great.
So it's definitely making my iPad sizzle these days. Good luck with your move and everything in Germany.
Thank you so much.
Professor Mtima, it's been wonderful having you back on the show. Very much enjoyed our discussion today.
Yes, thank you. I love to come back. This was indeed a very feisting and engaging conversation. One of the best conversations I've had all week, and that includes all my classes.
Well, that's great. We really appreciate your time and your insights. And Tom, it's always great to have you join us on TWiL.
Oh yeah, let me thank you for letting me this non-lawyer hang. I was right up there with Robert on representing the non-lawyer side. But great conversation. And Robert, let me just say, it's nice to know that there's a reasonable, intelligent person on your side of the debate. It gives me hope that we can actually come to a conclusion that will benefit everybody at some point.
Thank you so much. I appreciate that.
Yeah. Definitely. All right, folks. Well, this has been This Week in Law. We are going to get out of here. But before we do, I want to let you know that we record this show every Friday at 11 o'clock Pacific, 1800 UTC. We'd love to have you join us live at twit.tv when we do so. If you can't do that, please pick us up on iTunes or YouTube. One of the various ways that we distribute the show via non-commercial attribution Creative Commons license. And you can also check out our discussion points for each show at delicious.com/thisweekinlaw/ the episode number. This one is 181. We didn't get to much of what I wanted to discuss today on the show because the conversation was too wonderful, but there is lots of good reading material there if you'd like to check it out, and hopefully we can pick up those threads at a later date. And do email me. I'm Denise at twit.tv if you have comments, questions, suggestions for the show. We love hearing from you. Evan Brown couldn't be with us this week, but he will be back next week. He is Evan at twit.tv as well. So take care, everyone. We will see you next time on This Week in Law.